Mr. Thomas A. Mott, a civil service employee, was employed by the United States government for 9 years. He lived and worked in New Orleans. In 1967, he was notified that he was being reassigned to Fort Worth at the same salary. Mott contends that this was an adverse action and that he was entitled to a hearing. He alleges that his supervisor then wrongfully threatened him with disciplinary action if he failed to report promptly as ordered, but gave him a choice of retiring in order to avoid this action. This, he contends, coerced him to submit an application for retirement. 3 years and 5 months later, Mott filed this suit for reinstatement. The government promptly moved to dismiss it for laches. When he was notified of the impending transfer, Mott sought a rehearing through civil service channels. On February 13, 1967, the day he was required to report to Fort Worth, Mott contends his supervisor told him he would be subjected to disciplinary action if he did not report to his new station. The supervisor, he says, told him he could avoid this only by early retirement. He was later notified that his retirement application must be received in writing by February 22nd. The appeals examiner notified him on February 23rd that his reassignment could not be reviewed because it was not considered adverse action. The same day he submitted his retirement forms. Meanwhile, he filed an appeal from the examiner's decision to the Board of Appeals and Review, and he also sought administrative relief from the administrator of the General Services Administration. On March 20th, administrative relief was denied because of his retirement. On April 3rd, the Board of Appeal and Review refused to consider his appeal because Mott had elected to retire. Mott then set out to protest in every way conceivable to him. He wrote the regional administrator, who advised him in December 12th that it would not reconsider. He consulted 4 different lawyers, the first on March 26, 1968. Each one either refused to take the case or advised him, in effect, to seek relief through political channels. On March 11, 1969, he wrote the clerk of the United States Court of Claims for advice. In 1969, he also went to see another lawyer who said he was inexperienced in such matters and refused the case. Finally, he consulted the present counsel, who agreed to handle his case on a contingency fee basis. One thing is certain: Mott has never had a hearing on the merits of his contention by anyone. He has never had a chance to present testimony before any forum. If he has delayed reaching the courthouse so long, he cannot get a hearing here, and he is foreclosed from relief. United States, ex rel. Rand versus Lane, 249 U.S. 367, is the leading case on the subject of laches in presenting claims against the United States. Rand had delayed 20 months in suing the United States. It does not appear from the opinion what he did in the meanwhile, and the court affirmed the dismissal of the suit, saying, under circumstances which rendered his return to the service impossible, except under the order of a court